And counsel as to bond on these matters.
With respect to bond, Your Honor, I can only say that my client has expressed a keen interest in getting all these matters resolved once and for all.
Well, ma'am, what's taking you so long to come into court on these matters?
I was in jail and I was on tether for 2 years and I was unable to get the approved FOIA and the information's unavailable. She said she doesn't have any of the, actually my FOIA, sorry, paperwork is right here. She has no records seeking prior to May 5th, 2021, and no access to records. Wait, let me see, prior to August 2nd, 2007, and after May 5th, 2021. So I was unable to fight the charges and get the information for it. There's no tickets and there's no records of it at all.
I don't understand all that, ma'am, because
I'm challenging the constitutionality of it.
you're challenging the constitutionality of what, ma'am?
Of the stops.
Okay. And so who did you speak with that said that they didn't have any record of this case?
Your clerk. Here's right here. You want to see it?
I'll take a look at that, yes.
Alright guys, let's get into this mess. From the jump, this courtroom drama gets intense. The defense attorney opens with a vague attempt to settle everything once and for all, but the judge isn't buying it. The accused shows up after years of silence, blaming tethers and missing records for her no-shows. Records? Lost? Appearances? Missed. The judge grills her, why hasn't she been in court since 2018? Her excuses pile up like bricks in a wall of denial. Her answer? I was scared. That's not flying here. This is a courtroom, not a therapy session.
Prior to this, I was on a tether and I wasn't aware that I had a warrant.
Okay, just one moment, man.
Okay.
So this is indicating, this is from November 17th. And this is from the records department for the Wyandotte Police Department, not from the court clerk. Indicates any records you are seeking prior to May 5th, 2021 may not be available or partially available at this time. We are currently experiencing issues with that system and have limited access to it. At this time, we are only able to access records prior to August 2nd, 2007 and after May 5th, 2021. Sorry for the inconvenience. That's dated November 17th of 2023. Okay, great.
Right.
Great. That doesn't tell me why for the last 5 years you've not appeared in court on your 2018 matters, or why for the last 3 years you didn't appear on your 2020 matter. So why haven't you appeared at all?
I don't know. I had a tether on for 2 years, and I thought that if I had a warrant out for my arrest, that they would have picked me up on that.
Ma'am, what matter did you have a warrant out for your arrest on?
Apparently for you guys.
Okay. I'm sorry. What matter were you on tether for?
Let's stop playing games. The judge demands real answers. 4 years on a tether? That's what she claims. But the math ain't mathin'. She starts rambling about Lincoln Park, unknown officers, and untraceable cases. It's a fog of confusion. The court is trying to get a straight answer, but she just won't stop dodging. She's all over the place, talking about being scared, blaming broken systems, and bringing up constitutional challenges like she's in law school. The judge tries to connect the dots, but the picture just gets murkier.
Something with Lincoln Park for 2 years. I was fighting a case.
So, what years was that?
(2018) till 22. And I've been almost 90 days. And 2 years untethered?
That's 4 years. 2018 to 2022, that's 4 years.
Yeah.
You did 4 years untethered?
No, I did 2 of the years untethered because the officer, I was trying to explain it to him so he could help with this.
Okay, but ma'am, I'm not understanding what you're indicating either. The officer, what with the officer?
It's a case that's not out of Wyandotte.
Okay,
I mean, you're confusing me.
ma'am, I'm simply trying to find out why you haven't appeared in this court at any point on your matters from 2018 and 2020 until now. That's what I'm trying to figure out. Because I need to assess bond. I need to ascertain whether or not you're going to be showing back up for court, and you don't have a history of showing up for court. So I'm trying to figure out why you haven't appeared in court.
Well, I guess I was scared.
Okay. Are you currently on probation or parole anywhere?
No.
And so what happened, so you indicated that you were on tether on a case out of Lincoln Park.
Right.
Is that for the matter in e-course? If they're all at the same court, that's why I'm asking.
It was for River Rouge.
River Rouge. The matter from 2014? No, that's a traffic offense.
Buckle up. This part gets real shady. The court's still waiting for a solid reason for her disappearance. The judge straight up says it, you've got zero history of showing up, and we need to know if you're gonna vanish again. What does she say? I was scared. Again, come on. The court needs accountability, not pity. Then she admits, yes, there were issues in Lincoln Park, and yes, she was involved in some serious stuff. Even did time. But no answers, just vibes and confusion. The judge is not impressed, and things are about to heat up.
2020,
I have a problem with a specific officer that did some really talk about it, okay?
ma'am, I'm not showing anything from River Rouge on your record. I'm showing 2 matters from e-course.
See what I'm saying?
Well, I'm sorry, let me clarify. There's a matter from River Rouge, but it just shows there was a notice to appear. I don't show what happened as a result of your court date. But I'm showing 2 matters from e-course.
I paid $1,100 in fines. Okay? In Lincoln Park. And I did 90 days in jail, and I was on a tether for 2 years, and I guess I was just scared here, okay? I want to take care of this stuff, okay?
Okay. Ma'am, if you're tested right now, what's in your system?
Nothing.
Nothing.
Nothing but my doctor, that's it.
And what are you prescribed?
Boxing.
Anything else?
No.
So I'm gonna have you tested right now. And nothing's going to show in your system other than your Suboxone. Is that what you're telling me?
Yes.
Okay.
You better believe the judge is fed up now. Drug test time. The judge asks if she's clean. She swears it's just what her doctor prescribed. But when pressed to test on the spot, boom, refusal. Claims it's her constitutional right to decline. That's when the courtroom tension snaps. She's challenging authority now, shouting "throw me in jail then," and refusing to comply with basic bond conditions. This isn't just disrespectful, it's reckless. At this point, she's talking herself deeper into trouble with every word, every refusal, every excuse.
I came here on my own recognizance today.
Okay.
You
Okay.
know?
All right. And I've also seen you coming and going quite a bit along.
My son's at home with my mother-in-law or his grandma that is sick today. I take care of her, home health care.
Okay. I also saw you and Ms. Thomas chatting and then both leaving the courtroom. And so I want to make sure that you are substance-free right now. Are you substance-free right now?
I have nothing to do with her.
Yeah. I'm going to have you go over to probation and you're going to test right now. Is there going to be anything that's showing up in your system? I'm going to take that as yes. So what is going to show?
No, I refuse.
You refuse what?
That's against my constitutional rights. I am not gonna, no,
You're not going to what, ma'am?
I'm not gonna hold myself. I'm not gonna, exercising my constitutional right. I don't have to do that.
You don't have to what?
I don't have to go. You want to throw me in jail, throw me in jail.
If the court orders a condition of bond, ma'am, that you're to test,
Then throw me in jail.
then that's a condition of your
Then
bond.
throw me in jail. Okay, I'm gonna come back and take care of this. It's a stupid driving on a suspension, okay?
Well, and you have your current drug, possession of drug paraphernalia, and then you have a second driving license suspended. How'd you get here today?
I got a ride.
From whom?
My son's father. Mr. Hill gave me a ride.
How are you getting back home?
Mr. Hill, he's waiting for me outside.
Here comes the hammer. The judge starts laying out bond terms, and it ain't pretty. Multiple charges across multiple years, and she hasn't shown up for a single one. Failure to appear? Check. Driving unsuspended? Check. Drug paraphernalia? Oh yeah, it's all there. Bond gets stacked up like a Jenga tower. $2,500, $1,500, $3,500, and finally, $5,000. And every cent tied to her long list of no-shows and legal chaos. The court's message is clear. No more mercy. No more waiting. No more dodging.
Well, the court wants to make sure that you're going to appear in court because you have not appeared in court over the last 5 years. And so as to case number 184241, the court's going to indicate a $2,500 10% bond. In the event you post bond, no driving. 184242, the court's going to order $1,500 10% bond based upon your previous failure to appear. As to 20402, the court's going to indicate a $3,500 10% bond based upon your prior failure to appear. Then you post bond, no driving.
I can post on.
And on the possession of drug paraphernalia, 231363, based upon your history of failure to appear, the court's going to order a $5,000 10% bond. In the event you post bond, ma'am, you have to possess and consume the alcohol or drugs unless prescribed. You can be subjected to random testing. So, in the event you post bond, you are to make sure that you are contacting the court here, the probation department, within 24 hours of your release. To get set up with your random testing. All right, and we'll see you back on January 2nd. The court's going to also order, as a condition of bond, GPS tether, no house arrest.
Final shot, your move. And just when it seems like it's done, the court drops the final conditions. No drugs or alcohol, mandatory random testing. And guess what? If she posts bond, she better report to probation within 24 hours or it's game over. The judge is crystal clear. January 2nd, be there. Oh, and house arrest, GPS tether. She wanted to dodge court, now she'll have the court around her ankle. That's how it ends. Not with closure, but with a court that's had enough. Will she show, or will history repeat itself?